is now 11 o'clock. This is my 10-second warning that we'll begin hearing shortly. Good morning. My name is Rory Christian. I am the chair of the New York State Board on Electric Generation Siting and the Environment, or, as is known, the Siting Board. I call this meeting of the Siting Board to order. Before moving to the agenda, I would like to introduce the alternates representing the permanent members of the Siting Board. When I call your name, please confirm that you are present. Louis Alexander, alternate representing the Commissioner of the Department of Environmental Conservation.
Present.
Thank you. Dr. Elizabeth Lewis Michael, alternate representing the Commissioner of the Department of Health.
Present.
Thank you. Ann Wells, alternate representing the Commissioner of the New York State Department of Economic Development.
Present.
Thank you. John Williams, alternate representing the Chair of the New York State Energy Research and Development Authority.
Present.
Thank you. Madam Secretary, are there any changes to the agenda?
There are no changes to the agenda. However, I do just want to take this opportunity to remind everyone to please turn on your mic when you speak and speak loudly and clearly into the microphone. Thank you.
Thank you, Madam Secretary. We will begin with case 20-F-0043, application of the Garnet Energy Center, LLC, for a certificate of environmental compatibility and public need pursuant to Article 10 to construct and operate a solar generating facility and energy storage system in the town of Conquest, Cayuga County. It will be presented today by Judge Maureen Leary, Administrative Law Judge of the Department of Public Service, Greg Sayer, Administrative Law Judge of the Department of Public Service, Dakin LeCakes, Chief Administrative Law Judge of the Department of Public Service, Michael Stefanucci, Chief Administrative Law Judge of the Department of Environmental Conservation, Jason Zera, Chief of Environmental Certification and Compliance Office of Electric, Gas, and Water of the Department of Public Service, and Robert Rosenthal, General Counsel of the Department of Public Service, are available for questions. Judge Leary, please begin.
Thank you. Good morning, Chair Christian and members of the Siting Board. My name is Maureen Leary, and Judge Greg Sayer and I were the presiding examiners in this proceeding with Michelle Stefanucci, who is the Department of Environmental Conservation Chief Judge in their Office of Hearings. The order before you today grants a certificate of environmental compatibility and public need with conditions to Garnet Energy Center, LLC, pursuant to Public Service Law Article 10. This order represents the 18th certificate the Siting Board has issued for a renewable energy project since the passage of what is called the new Article 10. This project and the other renewable energy projects collectively represent a major step forward in New York's efforts to achieve its clean energy objectives, which are now codified in the Climate Leadership and Community Protection Act, or CLCPA. Today, after due consideration by and consultation with senior advisory staff, the Siting Board has before it a proposed order granting Garnet Energy the authority to construct and operate its solar energy facility in the town of Conquest, Cayuga County. This order is based on an extensive evidentiary record developed during the proceeding, which demonstrates that the Siting Board can make each of the required findings under Public Service Law Section 168, including: first, that the proposed facility represents a beneficial addition to the electric generation capacity of the state. Second, that the project's environmental impacts have been minimized and avoided to the maximum extent practicable, including but not limited to impacts to protected freshwater wetlands, streams and water bodies, agricultural lands, visual aesthetics, and cultural, historic, archaeological, and recreational resources. Third, the project does not disproportionately impact the local community. Fourth, It is designed to comply with applicable substantive requirements of state and local laws and regulations. And finally, that the facility will serve the public interest. I want to provide the Siting Board members with the roadmap to my presentation. First, I will identify the parties to the proceeding. I will then briefly describe the project, sketch the procedural background, including public and notice and comment, and other participation, discuss the settlement proposal submitted by certain parties, outline disputed legal issues that the Siting Board is resolving in this order, and I will identify the modification to certain certificate conditions that were a part of the settlement proposal. The parties to this proceeding included Garnet Energy, a subsidiary of NextEra Energy Resources. Also, staff from the Departments of Public Service, Environmental Conservation, and Agriculture and Markets participated. The Town of Conquest and a local citizens group known as Rural Preservation and Net Conservation Benefit Coalition participated. I will refer to the citizens group as Rural Preservation. And finally, Eugene Moretti, an individual who resides in the community in which the project will be located. The extensive evidentiary record on which this order is based includes the initially filed June 2021 application and the subsequently filed supplemental and updated application materials filed in September 2021 and January 2022, respectively. Garnet Energy and the parties also filed expert testimony, exhibits, legal briefs, and discovery. In March 2022, Garnet Energy filed a settlement proposal that contained proposed certificate conditions, a site engineering and environmental plan guide, or SEEP guide, and a complaint resolution protocol. DPS staff agreed to the proposal as a whole, but DE staff, who signed on to the proposal, objected to numerous certificate conditions and SEEP guide provisions. These were primarily related to environmental impacts presented by the project. So, although DEC staff agreed to certain parts of the settlement, it essentially disputed Garnet's position, that will sound familiar to the Siting Board, that certain wetlands at the project site that do not appear on the state's official freshwater wetlands maps were not subject to protection by the Siting Board, specifically under either Article 10 or Article 24, and the implementing regulations that require compensatory mitigation for impacts. Compensatory mitigation meaning the restoration or enhancement of existing impacted wetlands or the creation of new wetlands if wetland functions and benefits are adversely impacted or destroyed. The Town of Conquest and Rural Preservation and Mr. Moretti objected to the settlement proposal as a whole. Let me present a brief description of the project. Garnet Energy's application sought approval to construct and operate a 200 megawatt commercial scale solar electric generation facility with a 20 megawatt energy storage system and other associated components covering approximately 900 acres of a 2,288 acre project site. The project includes 12.3 miles of access roads, 25.5 miles of underground collection system lines, a 2.7 acre switchyard, a collection system substation on approximately half an acre, and associated parking areas, staging laydown yards, as well as a point of interconnection facility. Turning to public notice and comment of the proceeding and the project, it was robust and fair and open during the entire Article 10 review process. It included input from the host community Town of Conquest as well as area residents. The town and Rural Preservation were both awarded pre-application as well as application stage intervenor funds, which were used for the retention of counsel and consulting experts who provided information to the Siting Board during the proceeding. Public notice about the project was provided at significant milestones, beginning with Garnet's filing of the Public Involvement Program Plan that initiated the proceeding. DPS staff notably testified that the PIP plan, as it's known, was followed throughout the proceeding. Garnet Energy's application materials were made available to the public through the Department of Public Services Document and Matter Management System, or DMM system. It was also available on Garnet Energy's website and in the Town of Conquest Town Hall and local public libraries in the project area, where my understanding is there were hard copies made available. Garnet held several open house public meetings about the project, and the town also held a public meeting and provided the numerous public comments received at that time during the project. It's worth noting that the town, as well as Cayuga County, were instrumental in requesting and having the Judge Sayre and I visit the project site. Judge Sayre was with the parties in August, and both the Cayuga County and the town felt that that was critically important to the Siting Board's consideration of the project. Several notices related to the project also were published periodically in area newspapers. On February 3rd, 2022, Judge Sayre and I oversaw a department-sponsored afternoon and evening public statement hearing at which speakers expressed opposition to and support of the project. The comments of the public statement hearings were transcribed and form a part of the record. In all, the public submitted an additional 50 written comments on the DMM system, again expressing both support and opposition to the project. In conclusion, public participation was important. Turning to the relevant procedural background, on March 10, 2022, the agency parties and Rural Preservation and the town filed testimony regarding the application. On the same date, the settlement proposal was filed by Garnet. Garnet thereafter in April filed rebuttal testimony, and on May 6th we conducted an evidentiary hearing at which Rural Preservation cross-examined one witness, namely the Department of Agriculture and Markets expert Michael Saviola. Mr. Saviola testified about the project's impacts on agricultural resources. In June 2022, the parties submitted legal briefs addressing disputed legal issues. Notably, Department of Public Service staff expressed support in its brief for the settlement proposal. Essentially, DEC staff, the town, and Rural Preservation disputed whether impacts to wetlands and agricultural resources have been minimized or avoided to the maximum extent practicable as required by Public Service Law Section 1683. Turning to the disputed legal issues between DEC and
I'm sorry, Commissioner, is it possible we could take just a
Yes.
short recess? Guys, could we please resume?
Turning to the disputed legal issues between DEC and Garnet Energy, which deal with wetland impacts. Garnet's application identifies 45 wetlands totaling 613 acres that were delineated within the 2,288.7 acre project area. Garnet's updated application indicates that only 7 of those wetlands appear on the official state freshwater wetlands map, of which only 4 wetlands and adjacent areas, that is those areas within 100 feet of the wetlands, will be, quote, directly impacted by the project. In addition, Garnet's application indicates that a number of federal wetlands regulated by the United States Army Corps of Engineers will be impacted by the project. Garnet's application does not identify, however, the specific number of acres of unmapped wetlands and adjacent areas that may be impacted by the project. Instead, Garnet proposes to submit a final calculation of wetland impacts in the compliance phase following the Siting Board's issuance of the certificate. This approach does not directly comport with Article 10's requirement that the project impacts be identified prior to certificate issuance. See Public Service Law Section 1682. Garnet's application offers as minimization and avoidance measures for wetland impacts the use of best management practices. Again, this is not recognized necessarily as an appropriate mitigation measure in and of itself under ECL Article 24. Of note was Garnet's failure in its application to include with its application a mitigation plan to address the unavoidable wetland impacts, which is required by the Article 10 regulations. As the order before you recounts, the record lacks specificity and clarity regarding the total number of acres of protected freshwater wetlands that are both mapped on the official state maps and unmapped that may be impacted by the project. Those impacts are subject to minimization and avoidance measures as well as to compensatory mitigation, as the Siting Board found in the Northside Energy case F 17-F-0598. Garnet's application here and its legal position is due in part based upon its affiliate's position in Northside. Garnet argues that wetlands not appearing on the state's official freshwater wetlands maps are not subject to protection under Article 24 and by extension to the Siting Board's jurisdiction. As the Siting Board is aware, its August 2022 order in Northside rejected that very legal position and found that both mapped and unmapped wetlands and adjacent areas are entitled to protection. Notably, Garnet is an affiliate of Northside. While the order before you grants a certificate for the project, it rejects Garnet's position consistent with the Siting Board's decision in Northside. The order reiterates the Siting Board's broad authority to protect the state's wetlands. As the Siting Board found in Northside, several judicial and administrative decisions have reached a similar determination, including the Court of Appeals decision in Wedinger versus Goldberger, which rejected Garnet's narrow reading of ECL Article 24, that only mapped wetlands are subject to protection. Thus, although Garnet asserts that it has adequately minimized and avoided impacts to the maximum extent practicable, the order before you finds that more is required in terms of minimization, avoidance, and mitigation. As also discussed in the order, Garnet's application characterizes impacts to wetlands and to several other environmental resources as, quote, temporary, permanent, or conversion impacts. Conversion impacts falling somewhere between temporary and permanent. Although the Article 10 regulations call for an applicant to identify temporary and permanent wetland impacts, the order before you rejects this categorization of impacts in the context of minimization and avoidance measures. As the order finds, there is no basis for categorizing impacts as temporary, permanent, or conversion in the context of the requirement to minimize and avoid such impacts to the maximum extent practicable. Similarly, there is no basis for these three categories in ECL Article 24. As the Siting Board is aware, the Excelsior Order, Case 19-F-0299, recognized that project impacts to agricultural lands could be considered temporary because the land where the facility is located can be returned to agricultural use following the decommissioning and restoration measures required by a particular certificate. The order before you today distinguishes between those temporary impacts to agricultural resources and the impacts to wetlands and other environmental resources. It reaffirms the concept of temporary impacts to agricultural resources because of the decommissioning and restoration conditions, and the Siting Board's finding in Excelsior that agricultural impacts have been minimized and avoided to the maximum extent practicable. The order's express rejection of the concept of temporary impacts to environmental resources is based on the statutory protection afforded such resources under the Environmental Conservation Law. The Environmental Conservation Law expresses prohibitions for certain activities and sets forth a comprehensive permitting scheme that is supplanted by Article 10, but nevertheless represents a substantive requirement of state law. So, for example, this includes the prohibitions and permitting requirements in Environmental Conservation Law, Article 15, prohibiting activities in streams and water bodies, and in Article 24, prohibiting activities in wetlands. The Agricultural and Market Law contains no similar prohibition and lacks a similar permitting scheme. Turning to the certificate conditions that have been modified as a part of this order, those certificate conditions that have been modified are based on the conditions presented in the settlement proposal and include, first, the requirement for the certificate holder to submit a wetlands restoration and mitigation plan as a compliance filing that, among other things, sets forth the total number of acres of mapped and unmapped wetlands and adjacent areas impacted by the project, and that details appropriate restoration and mitigation measures. Second, modification of the certificate condition that provides for the allowable construction work days. This condition was modified to eliminate construction on Sundays as requested by the town of Conquest, but retains a separate condition allowing such Sunday construction hours under certain exigent circumstances. Third, the requirement to submit a plan to relocate an existing snowmobile and hiking trails in the project area that will no longer be available for recreational use. Certainly this not having been dealt with in the certificate conditions presented a level of safety concern based upon often snowmobilers utilizing trails at night and not necessarily having the ability to see changes in the project area where the snowmobile trails are currently located. Finally, the requirement to submit a more detailed visual mitigation and landscaping plan that addresses receptors identified in Garnet's own visual impact assessment and impacts to 3 additional residential property owners whose property is adjacent to the project. In closing, this order recites all of the required findings necessary for the Siting Board to reach in issuing the certificate under Public Service Law, Section 168. The order also expressly sets forth the requisite findings under the CLCPA, Section 7.2, namely that the Siting Board's issuance of the certificate is consistent with the CLCPA and will assist the state in achieving its greenhouse gas reduction objectives. Based on the record, we therefore recommend the Siting Board's adoption of this order. In addition to Judges Sayre and Stefanucci, who I would like to thank, I'd also like to acknowledge the work of several members of senior advisory staff, including Chief Judge Dakin LeCaix, General Counsel Robert Rosenthal, Article 10 Senior Advisory Counsel Heather Benke, DEC Assistant Commissioner Catherine Petronas, and importantly, DEC Deputy Commissioner and Siting Board Designee Louis Alexander. This concludes my presentation. We are available to respond to any questions that the members of the Siting Board may have. Thank you.
Thank you, Judge Leary, and thank you to the team who work behind this order. It's clear to me from your presentation today that in developing this order, we followed an open and transparent process, a process through which the free flow of information resulted in a healthy discourse, which was subsequently followed by actions addressing any concerns which were raised. This led to enhancing the benefits of this project to both the public at large and the local community. It's clear that this project is in the public interest, consistent with the CLCPA, and as you mentioned, supports the state's efforts to reduce greenhouse gas reductions. With that in mind, I support this item. And I turn to my fellow board members for comments and questions. I'll start with Mr. Alexander.
Thank you, Mr. Chairman. First, I would like to thank ALJ Leary for her thorough presentation today. In addition, I would like to thank ALJ Leary and the 2 other examiners as well as DEC and DPS staff for their work in addressing the significant environmental matters at issue in this proceeding. I have given particular attention to the wetlands discussion and the thoughtful review that appears on pages 39 to 50 of this order. I note as referenced that the wetland protections are properly meant to apply to both regulated mapped wetlands and the DEC jurisdictional unmapped wetlands. I note also this order's rejection of applicants' approach with respect to temporary permanent conversion impacts. The requirements as summarized on pages 48 to 50 of this order regarding the submission of a wetlands restoration and mitigation plan, the elements that will be required by the plan, and the review and approval process established, which are more fully detailed in Certificate Condition 122, are in my judgment well supported. I have reviewed the other aspects of this order and have no additional comments. Thank you.
Thank you, Mr. Ellington. I'll now go to Dr. Lewis Michael.
No comments or questions.
Thank you, Dr. Lewis Michael. Now, Mr. John Williams.
Thank you. No comments or questions.
Thank you, Mr. Williams. That said, I now will call for a vote. The vote is in
Sorry,
favor of the
Chair,
recommendations
Chair.
as described.
Excuse me, I'm sorry. Could you please call on Mr. Wells for comments or questions?
Oh, I'm terribly sorry. Thank you. Mr. Wells, do you have any comments or questions?
Thanks, Chair. No comments.
Thank you. Now I will call for a vote. My own vote is in favor of the recommendations as described. Mr. Alexander?
I vote in favor.
Thank you. Dr. Lewis Michael?
In favor.
Thank you. Mr. Well?
In favor.
Thank you. Mr. Williams?
In favor.
Thank you. The order is approved and the recommendations are adopted. Madam Secretary, is there anything further to come before us today?
There is nothing further today.
Thank you very much. And with that, I adjourn today's meeting of the Siting Board. Thank you, everyone.